Chapter 22, Corporations, Part 2, presented by Kelly Herzig. In this lesson, in Part 2, we will discuss the relationships between the major parties to a corporation and some termination issues. We will begin with the roles of directors, officers, and shareholders. We will discuss the duties of directors, officers, and shareholders. We will discuss the liabilities of directors, officers, and shareholders, the rights of directors, officers, and shareholders, the nature of takeovers, and termination. As we've discussed, the three major groups of people in a corporation are directors, officers, and shareholders, though employees in very large corporations are often a fourth category. Many times these groups have different and sometimes competing interests. State statutory law provides rules to ensure the three main groups work together to the benefit of all involved. Generally, directors and officers have the same general goals: to ensure the corporation survives and thrives, and that they stay employed. Shareholders usually want a maximum return on their investment, bigger dividends, and a higher stock price. This can create conflict within a company. To resolve these conflicts, the law gives legal rights and duties to the different groups within a corporation. We will begin with the role of directors. When a corporation faces important decisions, it is the board of directors that decide what course of action the company will take. Then there are elections. Typically, shareholders use majority vote to elect directors. However, at incorporation, because there are no shareholders yet, the incorporators choose the directors, or the articles of incorporation name the board of directors. The first directors serve until the first meeting when the shareholders elect a new board. The articles of incorporation, or the bylaws, specify the number of board members. In most states, the minimum number of directors is one person, which is true in Kansas and Delaware. The legal requirements for serving as a corporate director are very low. In most states, including Kansas, they do not even have to own stock in the company unless required to do so by the corporate articles or bylaws. Terms are generally for 1 year, but can be staggered so the entire board is not re-elected at each yearly shareholders meeting. Directors can be removed for cause, which is misconduct or failure to perform, but can have that removal reviewed for legality by a court. Next, we will discuss directors' meetings and voting. A minimum number of directors, which is known as a quorum, must be present to vote at board of directors meetings. If a quorum is not present, any decisions made will not be valid. You might as well not have a meeting and just go to lunch. In most states, the corporate articles or bylaws can set the quorum, but if those are silent, the quorum is usually either a majority of directors or 1/3 of directors like in Kansas, unless the board is one person. Most decisions only require a majority vote to pass, but sometimes major decisions require a 2/3 majority vote depending on the corporate articles or bylaws. This is for important things like mergers or dissolution of the corporation. Each director gets one vote and must vote in person, generally. Next, we will discuss the role of directors as a manager. Directors are responsible for many managerial decisions. They appoint, supervise, and remove officers. They declare and pay shareholder dividends. They make financial and corporate policy decisions. Some directors are also officers or employees of the corporation, known as inside directors. Directors who are not officers or employees of the corporation are known as outside directors. Outside directors are either affiliated directors who have business contacts with the corporation or unaffiliated directors who do not. Because of the large decisions to be made, directors often appoint one or more executive committees to handle the day-to-day responsibilities. Executive committees are specifically allowed by statute in Kansas. Next, we will discuss the role of officers. Officers are executive level managers the board hires to run the corporation. While directors are responsible for policy decisions, it is the officers who run the day-to-day business of the company. They're the ones in the trenches every day making decisions. Officers are agents of the corporation and may bind the corporation to contracts or other obligations under agency law. Qualifications for officers are generally set in the Articles of Incorporation and/or the bylaws. Generally, a person may serve as both director and officer of the company. Usually, it's beneficial to have at least one officer on the board who can report on the day-to-day operations of the corporation to the board. Next, we will discuss the role of shareholders and shareholder powers. Shareholders, through stock purchases, own the corporation. Shareholders do not legally own corporate property. Their names won't be on the title to any buildings, but they do have equitable or ownership interests in the company. Shareholders do not manage the company, but they elect a board of directors who do manage the corporation. Shareholders have powers given to them by both corporate articles and state law. Generally, shareholders have the power to approve major corporate decisions. Shareholders can also propose ideas for the corporation. If a shareholder has more than $1,000 worth of stock, under Security and Exchange Commission rules, the shareholder can submit proposals to be included in the next proxy materials sent out to all shareholders prior to the annual meeting. Next, we will focus on shareholder meetings. Unless there is an emergency, shareholders generally meet once a year at the annual meeting. The board, shareholders who own at least 10% of outstanding stock, and anyone else authorized by corporate articles can call what they call a special meeting. Before any meeting, all shareholders are given notice of the time and place of the meeting, and if it's a special meeting, the purpose of that specific meeting. A quorum of shareholders is required, usually requiring shareholders holding a total of 50% of the outstanding stock to be present. Once the quorum is established, resolutions can be passed by major vote of those present. However, some articles of incorporations or bylaws require a supermajority, usually 2/3 of those present to vote, to pass major corporate proposals such as a merger or dissolution of the corporation. Next, we will discuss shareholder voting. Usually, shareholders get 1 vote per share. That's the general rule, 1 vote per share. However, most states by statute require special voting processes to protect minority share rights. Cumulative voting, allowed in most states including Kansas, ensures that minority shareholders have a say in electing the board of directors. Cumulative voting divides shareholders into majority and minority groups, and each group has a set number of votes to cast in the board election. The number of votes is determined by multiplying the group's number of shares by the number of open director positions. Cumulative voting must be permitted by a corporation's articles of incorporation to be valid. So let's look at a concrete example. Suppose there are 8 director positions open. If the minority owns 2,000 shares, they have 16,000 votes. If the majority owns 8,000 shares, the majority has 64,000 votes. This allows the minority to elect at least 1 member because they will cast all 16,000 votes for 1 candidate. To outvote the minority on all 8 open positions would require the majority to outvote the minority on every position, meaning their candidates would have to get more than 16,000 votes. However, because the majority only has 64,000 votes, they cannot cast more than 16,000 votes for each candidate. That would require 128,000 votes. Therefore, if the minority casts all 16,000 votes for 1 candidate, they guarantee that candidate's election to the board. Cumulative voting is actually more egalitarian than 1 share, 1 vote, especially when you have many small shareholders. Directors, officers, and shareholders all have legal duties they owe the corporation. These are known as fiduciary duties. We will begin with the duties of directors and officers, which are similar. The first duty of directors and officers is the duty of care. Both directors and officers owe a duty of care to the corporation, meaning they must exercise due care when making corporate decisions. Courts interpret what due care means differently, but generally it means that a director or officer must exercise the care that an ordinary, prudent person would exercise in the management of his or her own assets. Directors and officers have a duty to act in the best interests of the company. Directors and officers have a duty to oversee management and must supervise, to a reasonable extent, employees who work for the corporation. They have a duty to attend director and corporate business meetings. Most importantly, they have a fiduciary duty to make informed and reasonable business decisions and can be liable to shareholders for any breach of this duty. Directors and officers have a duty to stay informed of important corporate matters, though they can fulfill that duty by reviewing materials prepared by others. If a director or officer is sued for breach of the duty of care for a business decision, the court will look to see if the decision had any rational business purpose. Was there evidence that the decision could have helped the company? And if so, generally there is no breach of the duty of care. The next duty that directors and officers owe the corporation is the duty of loyalty. Due to their power in the corporation, directors and officers have a fiduciary duty to put the shareholders and the corporation's interests above their own when making business decisions on behalf of the company. I served on the executive board at my law firm, which is organized as a professional corporation, for several years. One of the main duties was to set compensation for attorneys and staff. In making board decisions, it's always tempted to focus on how much you will be paid as an individual, but as a board member, I had to put that aside and focus on what was best for the firm as a whole, what would be best for everyone, not just myself. When directors or officers make business decisions to benefit themselves while harming the company, this is known as self-dealing. There are two types of self-dealing: business self-dealing and personal self-dealing. Business self-dealing occurs when a director or officer makes business decisions that benefit another company in which he or she has an interest or relationship with. Personal self-dealing occurs when a director or officer makes business decisions that benefit himself or herself personally. Often, self-dealing could lead to unfair business contracts or deals for the corporation. The duty of loyalty can also be breached by preventing corporate opportunity. For example, making sure that a lucrative contract goes not to your own company, but to a business in which the director has an interest. Also, owning an undisclosed interest in a competing business is a breach of the duty of loyalty. Or you can even start a competing company and not tell anyone. This is all self-dealing and is a breach of duty of loyalty. If a director or officer breaches the duty of loyalty and is sued and found to have breached this duty by self-dealing, for example, they are required to forfeit and cede all profits earned to the corporation. They have to give back their ill-gotten gains and give it to the corporation, which is the entity that should have had the opportunity to make those gains in the first place. Then there is the duty to disclose conflicts of interest. Because directors and officers may benefit from decisions made by the board and upper management, they must fully disclose any conflicts of interest that may arise in any corporate transaction. If a board member has a conflict of interest in a particular transaction, not only must they disclose it, the board member must also recuse him or herself from the transaction and abstain from voting on any issue that might affect the transaction. Now, a decision can be made by the board that will personally benefit a particular director or officer as long as there is full disclosure of the interest and the disinterested board members and/or the disinterested shareholders approve the decision. Now, there are going to be instances when conflicts of interest come into play. The key is to act ethically and make sure that any conflict of interest is fully disclosed and every decision is above board. Now think back to Chapter 2 where we discussed business ethics. I know that seems like a long time ago now. Business ethics involves the use of ethical principles to solve business dilemma. Ethical dilemmas involve questions about how one should behave that requires one to weigh the advantages and disadvantages of various stakeholders in the decision. For disinterested board members and shareholders, the key is to avoid not only the actual impropriety in decision making, but also the appearance of impropriety. That means making the decision transparently. Do you remember the different ethical tests for business decision making? When there is a conflict of interest, these tests can lead to better decision making. And one really stands out, and that's the public disclosure test. Imagine that the decision is being made on live television for all to see. You want it to be transparent, and that is how to avoid conflicts of interest, even if ultimately a shareholder or officer or director is benefited by a board decision. Next, we will discuss the liability of directors and officers to the corporation. Directors and officers have nearly the same fiduciary duties to the corporation, so the liability for their actions is also similar. So we will cover these topics together. The liability of directors and officers falls into two general categories: breach of fiduciary duties that harm the corporations, which we just discussed, and liability for torts and crimes, both those they commit and those committed by employees in certain circumstances. Now we will discuss liabilities for torts and crimes. You'll probably recognize some of these points as we have discussed these issues in previous lessons. Corporations can commit and be held criminally accountable for almost any crime, as the necessary mens rea for the offense can be imputed from the employee who carries out the crime to the corporation. Under respondeat superior, corporations can be liable for the torts of its employees committed in the scope of their employment, though not those of independent contractors it does not control. Directors and officers are of course liable for any crimes they personally commit. Directors and officers can also be held personally liable for torts and crimes committed by employees when they have failed to adequately supervise those employees. Under the responsible corporate officer doctrine, a court can assess criminal liability on a corporate officer even if the officer did not engage in, direct, or know about the crime if the officer has responsibility for corporate criminal compliance and has failed in that duty. This is articulated in the case of United States versus Park. It's a Supreme Court case from 1975. Directors and officers may also be held liable for wrongful personal transactions involving company stock. Directors and officers who use inside information to trade a corporation's stock for personal profit can be held personally liable in tort for breaching their fiduciary duty to shareholders, not to mention that it's illegal and a crime. Then there is the business judgment rule. Though officers and directors are expected to make decisions in the best interest of the corporation, they're not expected to make perfect decisions. The business judgment rule protects good faith decisions. If a director or officer was acting in good faith and had reason to believe the decision was a good one at the time, they will not be liable for any resulting harm under the common law in most states. Finally, we will discuss the liability of shareholders. The main liability that shareholders face is liability for the debts of the corporation up to the amount of their investment in the company. The company goes bust, they can lose everything. There are rare instances where shareholders can be personally liable, and I do mean rare. If a shareholder signs a subscription agreement to buy stock prior to incorporation, she's contractually liable to purchase the shares either at par, which is called face value, or at non-par value, which is fair market value. The shareholder would be personally liable for breach of contract if she fails to buy the shares as required. Now, if a shareholder is issued watered stock, this is stock issued below fair market value, the shareholder can be liable for the difference between what she paid and the actual fair market value or par value of the stock, depending on whether the stock issue was par or non-par. Next, we will discuss the rights of directors and officers. Directors have four major rights within a corporation. The first one is probably the most important one to everyone, which is the right of compensation. Directors have a right to be paid for their work. Many directors are also officers and are paid through that position. Directors can also be paid what they call a base retainer or honorarium, which averages at about $25,000 a year, plus payments per board meeting or board teleconference. Then there is the right of participation. Directors have the right to get involved in and understand every aspect of the business and be notified of all meetings. Then there is the right of inspection. Directors have the right to inspect all books and corporate records. And finally, there is the right of indemnification. Directors have the right to be reimbursed for any legal fees and potentially any judgments incurred in lawsuits against them. Now, officers have contractual employment rights as defined by their employment contracts with the company and under general employment law. Next, we will discuss the rights of shareholders. While voting at the shareholders' meeting is an important shareholder right, they possess other rights as well. They have the right to stock certificates usually. Corporations issue stock certificates to shareholders as proof of stock ownership, though possession of the certificate does not affect the right of ownership. If the certificate is destroyed, that does not destroy the shareholders' ownership in a company. Shareholders also have what they call preemptive rights. Under the common law, shareholders have preemptive rights, which gives preference to shareholders to purchase shares of a new stock issue in proportion to the percentage of stock they already own. This right allows a shareholder to maintain her proportionate control of the company. In most states, a corporation's bylaws can negate preemptive rights. If preemptive rights are available, all shareholders receive a stock warrant, which can be redeemed for a certain number of shares at a specific price within a given time period. Shareholders generally have the rights to dividends, though there are limitations on that right. If directors fail to declare and pay dividends, shareholders can sue to try to force the payment of dividends, though the burden is high because there are often good reasons to withhold dividends, such as financing expansion or product research. To prevail, shareholders have to prove that directors are acting unreasonably and abusing their discretion in withholding the dividends. An abuse of discretion standards is almost impossible to win. Then they have the right to inspection. Shareholders have the right to inspect corporate records under the common law and statutory law, though that right is also limited to protect from abuse. A shareholder can appoint an agent to do the inspection. They do not have to do it themselves. A shareholder can inspect corporate records, then they must generally make an advance appointment and demonstrate that they have a proper business purpose. Some states limit this right to shareholders with a certain minimum level of shares. Shareholders generally do not have the right to inspect confidential information such as proprietary or trade secrets and employee information protected by employment and privacy laws. Shareholders generally have the right to transfer their shares. Stock is generally freely transferred. However, in closely held corporation, there is an exception because there are usually restrictions on stock transfer to keep the stock in the family. One method of restriction is the right of first refusal. If corporate articles or bylaws permit it, shareholders have a right to purchase any stock offered for resale by a shareholder within a specific period of time. Then they have the right to bring about corporate dissolution. Shareholders have the right to petition a court to dissolve their corporation if they believe it can no longer operate profitably or engages in the following behaviors. Directors are deadlocked in managerial decisions and are harming the corporation. Directors are acting in illegal, oppressive, or fraudulent ways. Assets are being wasted or used improperly, or shareholders are deadlocked and cannot elect directors. Shareholders also have the right to bring two types of lawsuits. The first is the shareholders' derivative suit. If the corporation fails to sue an individual or other entity for damages due to harm caused the company, the shareholders have the right to bring a derivative suit on behalf of the company against the party at fault. Usually to have standing to sue, the shareholder must have owned stock at the time of the wrongdoing. There is a condition precedent. That means you have to do that before you can file suit. Shareholders must file a complaint with the board. If nothing is done, then the shareholder can bring suit. You must file your complaint first before you can bring your lawsuit. If you just bring your lawsuit, courts will a lot of times toss your lawsuit. These suits can be an important fail-safe if the directors themselves are the ones committing the wrongdoing, and you will often see derivative suits in this instance. Any recovery is paid to the corporation and not the shareholders, because remember, the shareholders are bringing the lawsuit on behalf of the corporation, and so the corporation is the one entitled to the recovery. Shareholders can also directly bring suit. Shareholders have the right to sue the corporation directly for damages caused by the corporation. For example, they can sue to inspect records or sue to force dividends. Any damages awarded are paid to the shareholder because these are brought in the shareholder's own name. Now we have finished up with the rights of all three parties. A good summary of the rights of directors, officers, and shareholders is in Exhibit 22-6. This might be helpful to you for testing purposes. Now we will briefly discuss two other corporate topics, corporate takeovers and then corporate dissolution. First, we will discuss the nature of corporate takeovers. Corporations can extend or expand their operations by buying a majority or even all the voting shares of stock of another corporation. This purchase allows the first corporation to gain control of the other corporation in a corporate takeover. So let's discuss the nature of takeovers. Takeovers are the purchase of a corporation's stock to gain control of that corporation. Hostile takeovers involve a takeover mounted by a hostile party, usually known as an aggressor, to which the targeted company vigorously objects. It usually involves wholesale reorganization of the target, dramatic policy changes, the firing of executives, and employee layoffs. You can see these are all good reasons why a target company might want to vigorously resist a hostile takeover. There are three general types of takeovers: tender offers, exchange tender offers, and cash tender offers. So we'll begin with tender offers. The aggressor can make a tender offer to target shareholders to buy their shares at a price above the current market value per share. Now, these are usually qualified offers that give the aggressor an out if the aggressor does not receive a certain number of shares within a certain time frame. Then there are exchange tender offers. The aggressor offers to exchange target shares for shares in the aggressor's company, though it does not have to be a one-to-one exchange. The last takeover type are cash tender offers, and they're the most straightforward. The aggressor offers to pay cash to target shareholders for their shares. After acquiring a substantial number of the target's shares, the aggressor initiates a proxy fight by fighting for control over target shareholders' proxies. An aggressor to make this work needs a list of target shareholders. Target corporations understandably want to protect this information, but federal security law requires a target company to provide assistance in some ways to aggressors, even during a hostile takeover. To avoid lengthy and expensive lawsuits, target corporations often provide a list of shareholders voluntarily. Because contacting individual shareholders can be expensive, aggressors often concentrate on shareholders with large blocks of shares. If an aggressor can obtain proxies from these types of investors, it can win control of the target corporation. Next, we will discuss the responses targeted companies can make in response to a takeover offer. After reviewing the material facts of the aggressor's offer, the target board has to inform shareholders of all the facts concerning the offer, and the board then votes to accept or reject the offer and advises shareholders accordingly. If directors decide that the takeover offer is not in the target corporation's best interest, there are many methods of resistance to try to keep control of the corporation. One common method is a self-tender offer, in which the corporation offers to buy its shareholders shares of stock for a price well above fair market value. A self-tender offer usually excludes a targeted number of shareholders. It's not intended to stop trade on its stock. Rather, it's an attempt to prevent a real or suspected hostile takeover. Targets can also defend themselves through leveraged buyouts. LBOs occur when a group within the corporation, usually management, buys all the outstanding corporate stock held by the public. Basically, they retain control by going private. It's very difficult to do, and it's very expensive. Sometimes there are better options. For example, a target board can find a white knight who is a friendly investor that acquires a corporation at fair consideration with the support from the target corporation's board of directors and management. The last topic we're going to cover in this chapter, part 2, is termination. While corporations can exist indefinitely under the law, the reality is corporations can and do end. A corporation is terminated in 2 stages, dissolution and then liquidation. Dissolution is the legal termination of a corporation, and it may be voluntary or involuntary depending on who initiates and who compels the dissolution. Voluntary dissolution occurs when the directors trigger the dissolution by initiating a termination proposal and submitting that to the shareholders for a vote, or the shareholders can begin dissolution procedures directly. Shareholders must vote unanimously for dissolution. Involuntary dissolution results when the government or private parties successfully get a court order dissolving the corporation. Once a dissolution begins, the directors must file articles of dissolution with the Secretary of State, which include the company name, the date of dissolution, and the method of authorization of dissolution. Next, the directors must give notice to the shareholders. If shareholders or creditors have claims against the corporation, they must give notice of those claims, usually in writing, within a stipulated time. Although the corporation establishes the time frame for claims, the period must extend at least 120 days after the date of dissolution in most states by statute. Internal Revenue Service regulations that apply to all corporations, as well as rules in the corporation's home state, determine how liquidation takes place. State requirements specify the information a liquidation plan must include. In general, a liquidation plan outlines a corporation's promise to return excess assets to shareholders as specified in state regulations and identifies the date shareholders cease to have rights beyond receiving a final distribution. Liquidation actually occurs when the board of directors sells all the corporation's property and assets and converts them to cash, pays valid creditor claims, and does a final distribution to shareholders in exchange for their stock. This is the end of Chapter 22, Part 2.